Hello, everyone, and thank you for attending today's Integrating Doctrine and Diversity Speaker Series event. My name is Greg Bowman. I serve as the Dean at Roger Williams University School of Law, and we're so honored that you've taken time out of your busy schedules to join us today for this important event. Per our tradition and in support of our values, I'd like to start us off today by reading our law school's land and labor acknowledgement. So as we begin our program today, I want to take this moment to reflect on the lands on which we reside. We are coming here today from many places, and we want to acknowledge the ancestral homelands and traditional territories of indigenous and native peoples who have been here since time immemorial, and to recognize that we must continue to build our solidarity and kinship with native peoples across the Americas and across the globe. Roger Williams University School of Law is located in Bristol, Rhode Island, and so we acknowledge and we honor the Narragansett and Pokanoket people, as well as Soams, the original name of the land on which our campus sits. We also acknowledge that this country would not exist if not for the free, enslaved labor of Black people. And we recognize that the town of Bristol and the very land on which our campus resides have benefited significantly from the trade of enslaved people from Africa. The economy of New England, of Rhode Island, and more specifically of Bristol, was built from wealth generated through the triangle trade of human lives. During this time of ongoing national reckoning with our history of slavery and the disparate treatment of Black people, we honor the legacy of the African diaspora and the Black lives, knowledge, and skills stolen due to violence and white supremacy. As we gather here today, the movement for justice and liberation is building in our country, and yet many are still being met with violence and even being killed, while other people in our country actively work to stand in the way of progress. So as upholders of justice, our hope is to become agents of change for members of our society who have been met with violence, physical, mental, emotional, through our privilege. And as upholders of justice, we believe that our students, who soon will be practitioners of law, can be and already are agents of change as well. So thank you very much again for being here. It is now my pleasure and honor to turn the program over to my faculty colleague, Professor Nicole Dyszlewski. Nicole, take it away.
Thanks, Greg. Welcome to Echoes of Slavery, a deep dive into the Citing Slavery Project. I want to start by saying a few words on where we find ourselves today. I read this quote on social media this morning as I was doom scrolling, which helped me reconcile the idea of spending an hour today talking to all of you, with all of you, about America's history of slavery, legal citation, and pedagogy, when I stayed up all night and I feel a bit tired and out of sorts. The quote of unknown attribution states, "One of the greatest challenges of being alive, to witness the injustice of this world and not allow it to consume our light." My coworker texted this morning, "One thing I know for sure is that my own sanity and safety must be protected. I don't have energy to feel despair. Being positive and staying optimistic will take all the energy I have. Cheers to gratitude for this beautiful sunny day and the ability to move our bodies and use our minds." So today I'm not using my Zoom background. I am just here with you in community, in gratitude, with the light shining through the windows, not allowing anyone or anything to consume my light. But I do want to say, if you can't stomach this webinar today, I suggest you use this hour to take a break. Walk around, call your bestie, enjoy a pumpkin spice coffee treat. This is being recorded. It'll be online. I understand that the work of integrating doctrine and diversity takes a balance of peace and bravery, and today you might need more peace than bravery. That being said, let's go. So I would like to introduce Justin, and my first question is for Justin. Justin, can you share a bit about the history of your project And can you tell us all exactly what the Citing Slavery Project is?
Yes, and thank you so much for inviting me and some of my team members to talk today. I appreciate all of you, not only organizers, but also the people who are in attendance today, for taking time to learn about our project. Yeah, I hope that you'll find it to be both, I think hopefully you'll find this both troubling, but also we'll hope to provide real action steps that you can take to help address some of these problems. So I want to share a brief presentation here just explaining about the Citing Slavery Project. This project originated with a surprising discovery. It happened accidentally as I was working on my dissertation, that American courts in the 21st century were still citing cases involving enslaved people as good law. That discovery turned into an article, which, with the help of my programmer sister and a great group of students here at MSU and elsewhere, turned into the website and the project that we have today. So first, let me explain a little bit behind the impetus for the project by giving you an example of what we deem a slave case. That is a case that involves an enslaved person. In Tire Shredders, in 1999 case from the Tennessee Court of Appeals, the court faced a simple question of law. Could a jury award damages both for loss of use and decrease in market value for in a case in which basically there was damage to a tire shredding machinery? And in coming to its decision, the court cited Johnson v. Perry, an 1841 Tennessee case involving an enslaved person, a man who is himself considered property. So here's a direct quote from that Tennessee case, the modern one, not the old one, in which the court is treating that enslaved person just like a piece of property. And I'll read it just in case it's hard to read on the screen. The court held that if the injury had been temporary, the plaintiff could recover damages for loss of the slave's service. If, however, the slave had been permanently injured, the plaintiff could recover damage for the deteriorated value of the slave in lieu of damages for loss of service. Finally, if he had been killed, the plaintiff would have been entitled to damages equal to the actual value of the slave, but would not have been entitled to recover damages for loss of the slave's service. So this modern court is analyzing this case about damage to a human being like any other case, no differently from the next citation, a case about damage to a car. Johnson v. Perry, however, didn't involve a car. It involved David, who was an enslaved man in Tennessee. His case arose when people were trying to track him down and punish him, a group of white men. He was fleeing from them. He fell while leaping into a creek to evade his pursuers, severely and permanently injuring his leg. Although the court blamed David for his own injury, they compared him needlessly to a frightened animal. They ultimately awarded damages to his owner who brought the suit. And so this kind of callousness to David as a piece of property was a natural result of slave commerce. In such a context, the Johnson court's decision to award David's owner damages for his injuries followed the twisted logic that such a system demanded. We are collecting cases like this and the cases that cite them in order to make this history accessible to historians, teachers, and lawyers in hopes of encouraging them to confront this ongoing legacy in law. Now, to understand why these cases continue to influence law, we need to understand where they came from. Slavery, as the opening remarks from the dean suggested, was a massive institution. It affected not just in the South, but all across the United States. And because of that, that economic activity generated thousands of cases. So we estimate that appellate case reporters contain more than 15,000 cases involving enslaved people. And these cases cover just about every area of law you can imagine. This is a word cloud done just by the cases from the cases in Louisiana that we've classified. And you can see that a lot of what you see here is just routine issues of private law. And as the word cloud illustrates, lawyers use their expertise to fit these cases into long-standing legal categories that they shared not only with other Southern lawyers, but with Northern lawyers as well. So let me just give you a few examples. So a dispute about whether someone had authority to sell an enslaved person was classified along with cases involving non-human property in the law of principal and agent. The question of whether someone had a right to seize enslaved people was a matter of the law of debt. And a question of borrowed enslaved people, essentially like renting out people, was a question of conversion of property when someone held on to that person without agreeing to return them. So these are just a few examples, but this happened thousands of times with everything from disputes over contracts, technical rules of inheritance, and warranties. If ever there's a clear opportunity to remove that law of slavery, it was in the wake of the Civil War, but with the Reconstruction Amendments, there's a real possibility there. But American lawyers limited the radical possibilities of emancipation by continuing to treat these cases involving enslaved people as if they involved non-human property. The Supreme Court even continued to require people to pay installment contracts for enslaved people. So although the world of slave commerce had been uprooted, its legal legacy remained part of U.S. law. So our goal with the Citing Slavery Project is to document these cases and their legacy. This is a representation of the cases we've uploaded so far. So we've collected and uploaded 11,000 cases. And to find these cases, my team of students has combed through commercial legal databases to identify cases we know involved enslaved people. I'm happy to talk more about that if you want to know our methods in the Q&A. We then collect identifying information on the case, the names of the enslaved people involved, and the legal subject matter of the case. And so we've uploaded, like I said, more than 11,000 of these cases on our website. We're still working on South Carolina and Kentucky. You can see there's these cases are scattered throughout the South, but also even in the Northeast as well. Names are mentioned in only 30% of Louisiana cases. So this is a word cloud of the names involved, the most common names used in these cases. And you can see unnamed is large. It would be much larger if this is proportional. Here's a closer look at the names of the people in these cases. And I include this slide just to remind us that each one of these cases, even if the person was unnamed, involved a human being, that the courts even very rarely recognize their humanity. So in addition to documenting this dehumanizing treatment in the 19th century, we're also documenting cases that cite to these cases. So originally, I recovered roughly 350 direct citations by modern American judges to slave cases in the last 35 years. You can see they're scattered across the country. But thanks to the research we've continued to do, we've found more than 50,000 cases that cite slave cases, and 1,400 of those in the last 35 years. So every state in the United States, except for Nebraska, has cited a slave case in the last 35 years. Now, most of these cases don't look like tire shredders, and not all rely on cases that treat enslaved people as property. In total, however, like the tire shredders court, judges in many of these cases cite them for basic propositions of law and property, evidence, civil procedure, criminal procedure, statutory interpretation, torts, and many other fields. And in roughly 80% of these cases, we found the court that cites the slave case does not acknowledge the case's slave context. And we think that citing these cases without acknowledgement causes both legal and dignitary harms. So first, these cases often require courts to recognize that enslaved people differed from other types of property. And so these cases can therefore provide unclear precedent. For example, a case about slave hiring could be precedent for bailments cases or employment law. Second, these cases are based on reasoning designed to protect slavery in many cases. Especially later in the 19th century, courts recognized that slavery is under attack, and so they draft cases, write opinions that are protecting that rather than reaching the ideal legal rule. So those are the legal harms. The dignitary harms, I think, are just as serious. If we're citing these cases without acknowledgement or some kind of recognition of what's in them, we're disregarding the white supremacist language and reasoning in those cases. We're also hiding the role lawyers played in facilitating slavery by not acknowledging that the case we're citing involves enslaved people. And finally, and this is, I think, most important, by citing these cases without recognizing the issues here, they're continuing the dehumanization of the law of slavery. So just to give you an example, in the tire shredders court, the only way it makes sense for them to cite to that Johnson v. Perry case is that they continue to treat David as property. Otherwise, the citation would be inapt. And so there's not only dehumanization in the 19th century, it's continuing today. So we are making this legacy accessible on our website, www.citingslavery.org. We have a list of cases in a lot of different states. You can click on these cases, not only see our brief summary of the case or the subject matter of the case, but also see the cases that have cited to that case. So here is Johnson v. Perry that I talked about at the beginning. You can also access a full text copy of Johnson v. Perry through the Case Law Access Project. And here's what happens if you click on tire shredders. You can see that these cases are, cited, even in the 90s and 2000s. Once we've completed our database, we hope our users will not only be able to study the history of the law of slavery, but also uncover its connections to the present. We're really excited to tell you more about our work, what we're working on, our newest updates, and look forward to your answering more questions, both from Nicole and the audience. So just quickly, if you want to stay in touch, you can visit us at citingslavery.org, follow the project at Citing Slavery, or just reach out to me via email. I'd love to hear from you. So that'll stop sharing, and look forward to hearing some questions.
All right. I'd also like to bring up Misty, Nina, and Torrance. Justin, do you want to tell us a little bit about who Misty, Nina, and Torrance are?
Sure. So this project, as I mentioned in the presentation, could not have been accomplished without the extremely hard work of hundreds and hundreds of hours of student work. And these are three of the students who have worked on the project, both in collecting cases and doing some of the other work of the project. And so I brought them here to talk both about their experience working on it, but also what they've learned from the project. You'll see why I'm so lucky to have wonderful students working on the project. They're not only are they really great at the work, but they're also very thoughtful about the work that we're doing.
Thanks. And thank you, Nina, Misty, and Torrance for coming today and sort of sharing of yourself. So my first question is sort of what Justin said. What is the impact that this project has had on your views of systemic racism in the law and on our country's legacy of slavery? And you can answer that in whichever order you prefer.
All right, I'll let the students get first dibs at it. You want to start, Misty?
Sure. Since you called me, how has it impacted me? I think overall that this work has made me more present in the moment, because before I learned about this project through another presentation by Justin, and I think Torrance was there also. I was thinking about that earlier. And before I had been in that case, I knew there was a great deal of slavery in the law and all of those things. But I am from Oregon, so when I listened to the presentation before that, it suddenly opened this door, like, oh my goodness, if all these things are still spreading through our current history through these old cases, then Oregon, yeah, we've got a long history of that kind of thing. And so I became hyper aware. And now when I just graduated, but when I would go into classes and I would have discussions about cases that involved slavery, in particular one involving redlining that I recall very vividly, it changed the way I engage, and I wanted to make change. And I think that was the most important thing to me, is now that I was more aware of the currentness of this issue, I was able to contribute and live to my values in a way and do something about the racism that is still present today.
Nina, you want to chime in?
Yeah, absolutely. And thank you so much for having us. We're so excited to be here. My name is Nina. I'm a 2L at Duke, and I have been involved in collecting cases and research. I met Professor Simard and learned about this project at a conference last year. And for me, I think the project has done a couple of things. I think I went through 1L and recognizing where there are cases where I thought, there might be more to the story, like cases in contracts that are particularly old, like lack very particular facts, and are based in particular places. And you sort of get this sense that like there's this undertone that there are enslaved people either involved, or the parties who have the dispute are enslavers. And so in that case, this project has affirmed for me kind of what I suspected. It also, for me, makes me feel heard and seen. Like in my con law class, my 1L year, I remember we did this case, State v. Mann, relatively famous case, and you can Google it, but basically the holding that our professor wanted us to draw from the case was that there is a circle of activities that the law will not touch, and slavery is that circle. And I think for me, that was really hurtful, to have to like internalize that message that like the law is just not going to touch slavery, when in fact doing this project we learned that the law touches slavery in so many ways, and there are so many like ridiculous rules just about slavery and about the color of your skin. And then lastly, I think it has brought me some peace and softness. One of the things that we do is record people's names. And so to look at a case that maybe nobody else has looked at in the last 10 years and like take down someone's name and put them in a database, like that brings me peace. Like I think about my own ancestors or like that might be in this data set, and like brings me some comfort to draw some attention to the atrocities that they lived through.
Hi, my name is Torrance, and thank you guys for having us. I am a 3L at Michigan State. For me, I worked in DEI at the University of Notre Dame for 4.5 years before I came to law school. So this was stuff that I was already engaging in. And I think that it more so as someone who was a student of history myself, who studied political science in undergrad, I had done the work to learn about those areas of our history in which our typical public school education curriculum would not discuss, or that even many classes, like entry-level classes in undergrad, don't discuss, because it's either there's a lack of knowledge by the professors or the institution, or there's discomfort with actually engaging with those topics. But I feel strongly about the fact that, similar to the way that we say, we don't want to talk about controversial issues in current times, they say we don't want to talk about politics, or we say we don't want DEI because it's a program, when really I see those things as talking about politics is dealing with reality, and dealing with DEI is about reckoning with our history. So that's just dealing in facts and reality. And I think as legal practitioners, as legal educators, that we have a duty to be well-informed and to deal in facts and not to deal in hyperbolic rhetoric or political rhetoric that tries to obfuscate facts and reality. And I just think that this has really opened my eyes in a way that it's not just about me finding it important because my personal connection to it, but how I think that it's really valuable for us as a society and as a profession.
I said it as well as I could, for sure. The one other thing I would add is that I think it's made me think differently about legal reasoning. So related to what Nina was talking about, what are the things that are the relevant histories that courts are interested in, and what are the irrelevant histories that are not interested? And I think that is something that's still very applicable today, right? What are the things we can abstract from and say that doesn't really matter for this holding, and what are the things we can't? And one of the goals of this project is to make us, I think generally slavery is is fallen in the category of things we are allowed to abstract from. And we're trying to encourage judges and lawyers to rethink that and say, does it actually make sense to take this law out of the context which was developed?
Thank you all. That was really wonderful, and it really resonated with me. Maybe on a day that I needed to feel like we were all here together. So we started this series, Integrating Doctrine and Diversity, based on 2 books that I was a co-editor on, for a similar reason than I think some of you said, which it feels sometimes like there's this disconnect between sort of what we're talking about in class and sort of the realities of our history, how this history impacts the students who are actually taking our classes in the moment, at this time. So not a theoretical student, but an actual student who's in front of me. And so that's sort of where Integrating Doctrine and Diversity comes in for me. And it's just nice that there are these other projects who are doing this similar work. So this is not theoretical work. This is actual people who had names, and those people can be sort of rediscovered or discovered as people legally for the first time through the work you're doing. And that this isn't some esoteric thing. This is happening every time that we cite a case, which is a slave case, or a case that cites a slave case, or a case that cites a case that cites a slave case, it's very much alive today. So thank you all. You all sort of took a piece of that, which was so wonderful. And I'm really grateful you're here and for the work. And I prep for this by like reading everything there is about what you're doing. And I read this Harvard Law Review blog that said, quote, "The Blue Book is a moral document. And I hope those students that come after me will consider that and the importance of language when updating it, not only in the form of etiquette that the citations themselves represent, but also in who has access and upon whom the rules are being imposed. The law needs it." End quote. Can you, anyone who wants to jump in, talk about Blue Book Rule 10.7.1D? What does it say? What is the relationship with your project and the rule? And if you could talk a little bit about, should this be only academic, and why should state court ears be perking up right now?
Yeah, thank you. This is one of the a success that I still I'm very, very proud of, and happened relatively early on when working on the project. When I was writing the first article that started all this, a friend of mine suggested that we might want to encourage the Blue Book to have a rule that requires people to acknowledge when they're citing the slave case. And we got it. 10.71D requires that if you're citing to a case in which an enslaved person is a litigant or a party to the case, that you should acknowledge that. Remarkably, and I think this speaks well of the upcoming generation of lawyers, it was actually quite easy to persuade the Blue Book to add 10.71D. So I reached out to the editor of the Blue Book and sort of, wrote a paragraph saying, here's what I want you to do. You want to have a conversation about it? We talked over Zoom, and he and the rest of the editors were enthusiastically supported the proposition. The only downside, the thing that upset him was that they had just finished the 21st edition of the Blue Book, so they had to put it in the second printing. But it was remarkable how enthusiastic they were and interested in doing this. And one of the things that's unfortunate about the way we did the rule is that this is in the white pages. And so those of you who don't know, there's, the blue pages and the white pages of the Blue Book. And so the white pages are for academic writing. And it's been remarkable how journals are following the rule. It's very exciting to see. But most jurisdictions, if they use Blue Book citations, use the blue pages, which are much more limited and don't include this rule. And so the pitch I would make to a state court system is that this would be a great opportunity for you to add a local rule that requires some kind of acknowledgement in lawyers' briefs. And I think it's important for two reasons, not only for the dignitary reasons that we've talked about, but also for just making better law, right? If you are a judge or you're an opposing party, you probably want to know if the precedent that someone is relying on comes from a case involving an enslaved person, because you might want to read it again, right, to make sure it's still makes sense to cite it as good law. And so that's the goal of the Blue Book rule. And I have been excited to see that some courts have actually started using it, even though they're not mandated to. And I think that shows that this is not just purely like an academic issue, but also that it's it's an issue of making sure that we're drafting persuasive opinions and making the right decisions.
Anyone else want to jump in? Okay. So I have a follow-up on this. Have you tried to have any of the legal research databases follow suit and have some type of a flag or notification, like in a Shepherd's report? And how have those conversations gone, if they've gone at all?
We have. There have been people who are quite interested, and then it seems to lose interest as it goes up the chain. We haven't pushed too hard, in part because I wanted to finish collecting the cases so we could just sort of hand over the cases and say, just flag these ones, right? But I also, I think the Blue Book rule gives these commercial legal databases another reason to do that, because it requires this flagging of them, so that it helps your users, meet their what they're supposed to be doing under the rule. But we are working right now with the Free Law Project, which provides a free database of legal cases to start implementing a flag. And they're very excited about it and are working with us to do that. So hopefully that would also put a little pressure on some of the other databases to, maybe reconsider things.
And we have a question, which I imagine is from some LP professor somewhere who teaches legal writing but uses Allwood. Is there a similar rule in Allwood, or is there any conversations about that happening, perhaps?
No, but there should be. So that's a thank you for flagging that for us. That's a great suggestion.
That's what we're here for today, Justin, to give you more things to do. So I'm going to get into some of the controversy. Some people disagree loudly with the Blue Book rule. I have a very long quote here. So quoting one critic, "I think the upshot of this regime is that scholars will simply stop citing articles with a slavery parenthetical. Given today's culture, why would any professor willingly litter his or her footnote with the mark of original sin? Asking a research assistant to shepherdize a slavery case could itself be a traumatic act, and this outcome will not be limited to legal scholarship. Progressive law clerks can now insist that judges should stop citing slavery cases. Recently, a Massachusetts court refused to use the word grandfathering, even though the term predated its Jim Crow usage." And we're sharing in the chat the link to some of this so you can sort of read it yourself. And junior associates will refuse to embrace slavery cases. Partners will have to give in. With this subtle procedural change, the crits will quietly accomplish a long-term goal. In fairly short order, entire swaths of jurisprudence will be canceled, and this erasure will be indiscriminate. And this goes on and on and on. For a while, I really thought I think it's worth reading as a whole instead of just a quote. But I just wondered if any of you chose to respond, what might your response be to this concern?
Torrance, I'll give you the first crack.
Yes, thank you, because I do have a lot of thoughts about this specific question. One, I want to say I think people should read the article. I definitely take umbrage with the fact this author decided that it was funny to use the parenthetical around the word slavery in this, mocking the rule. I also think that it shows in the way that he frames the questions are framed that it is an unwillingness to engage with the material, because we've gotten this pushback in many areas, and we've answered the question a lot of times. That one thing that I want to address is that we've never asked someone not to use a case, and we're not necessarily saying that it's always bad to use a case. That one, these cases are good law where they still remain good law, and we don't challenge that. That's not something that we're looking to change, but that we think that to what we've already talked about, the facts of these cases that do provide for legal propositions that people are using in briefs and in memos, not citing it as a slavery case or not illustrating that it's a slavery case in the facts, that engaging with that is what's important, because I think that we would agree that at the basics of legal education, when we are being taught to say, write our first memo, and it's about like facts or distinguished facts, that you can't just say that a tire shredder machine is the same thing as a human being. That is simply not, even if the legal proposition stands, which I think that I can even concede that when you just take the legal proposition, that it still logically follows what we understand to be in that area of law. But that I don't think that as a country has decided that obviously slavery was our original sin. It was a horrid practice. It is a scar on our Constitution, in my opinion, that it's really important for us to engage with that discussion. And I think that if you have to use the case, you have a duty to use the case if it's the best legal proposition for your client. But where you are using the case, I think it's important for in your footnote that's an opportunity for you to engage with why you use that case, what the ups and downs, and how it relates to the topic that you're writing about. We're just asking people to actually engage with it. And I think that we all know that the larger issue around slavery is that people are uncomfortable with engaging with it, but it's not like, guilt is not a helpful emotion, and that having the shame is less important than us having a strong intellectual discussion about, the legacy of slavery in this country. I also think that, they make a point in this article that this will just kind of allow for these cases to fade to black, because people will just stop citing them. They won't use them. And then is that kind of going against the intent of our project and the work that we're doing, because we want people to engage with it? So people just don't use them. To a degree that there's a positive there, because we think you shouldn't use the case if you don't need to use the case. If there's another case that would give you the same legal proposition, why use the slave case? Maybe engage with that question, but that, I think that's why we are advocating for the use of the rule, because we don't want them to fade to the back, and that we're not discussing this as we move forward in our country's history, but that by engaging with it, we are able to reckon with it, maybe come up with solutions to the issues we still face as a society as a result of it, in our legal profession as a result of it, and ultimately, if hope still exists on a day like today, maybe heal a little bit from it.
Missy, you want to add something?
Very much. This question, and in particular this quote, hit me hard, because the way it was phrased or stated was, in my opinion, fear-mongering. We should be afraid of this happening, so we shouldn't do it. We shouldn't reconcile the fact that we are treating people like property. As Torrance said, we're not suggesting that these cases not be used, but I think the people that we are citing to who were, I should say, use my proper tense, enslaved people, deserve to have a name, deserve to be recognized for what they've given us, which is part of our society. This is building blocks, and that slippery slope argument of, if we do this, then this happens and this happens, is not supported. It's not fair to the people. It's not fair to our past, and it's not fair to us. I don't think there is a way to address the very real and very present racism that we deal with today. And I say this as a privileged white woman, though I am disabled, that we can't address that issue unless we look it in the face. And looking it in the face starts with naming it out loud.
And just one thing to add to those two comments. I mean, it isn't happening. I mean, people are still citing these cases. It's just they're acknowledging them, and I think that's ultimately our goal. I mean, I think there's some cases you shouldn't cite to because it doesn't make sense. The analogy doesn't work, as Torrance was saying. But I think as they both said, like, this is an example of someone. I don't think it's a principled objection. I think it's more of an objection out of tradition, or maybe less generously laziness, not wanting to engage and think about things that I haven't had to think about this in the past. Why should I think about it? Nina, you want the last word on?
No, I don't really have too much to add. I again continue to appreciate working with all of you, because anytime you answer a question, I'm like, wow, what a great point. I don't have much to add. I would just highlight that the uncomfort that the author feels here is important, and like we should tug on why that is. And the whole point, to me at least, of in part citing these slave cases is to really start to think about, why did we treat people like property, and are these principles still good? And if they're not still good, we shouldn't use them. And if they are still good, we need to say, like, okay, this was about David, this was about Peggy. Like, there needs to be the humanization of people, kind of like what Misty and Torrance and Professor Simard you've already said.
To go back to the quote itself, it sort of continues, and it talks about the way in which the New York Times flags whether a person, this is a quote, flags whether a person is a Black man or a Black woman with a capital B. And then it talks about, I suspect journals will force authors to put preferred pronouns in the author note. There's this, I think to me, the issue is not about, well, what all the expectations are going to change. And it's not just about, to me, about footnotes or parentheticals. To me, my series is integrating doctrine and diversity, so my real focus is doing that. It's talking about it. It's feeling uncomfortable and doing it anyway. We've been teaching cases which touch on the lives in sometimes horrific ways of enslaved people. That's part of our job. We're not going to do that. We're not going to have one of these cases. We're not going to go through law school without teaching you this. So why not teach you all of it? Why not talk about all of it? Be in the discomfort. And so I guess my next question was, can you share about how the project and the work it's doing can be integrated into first-year classes? I know that we're doing that here at Roger Williams a bit, but I wanted to hear how you might be doing that in sort of traditional doctrinal classes or podium classes, or even experiential learning classes or legal research and writing classes. I invited you because to me, this isn't like a footnote issue. This isn't a side issue. This is a pedagogical issue. And I want, the people who show up at these are largely people who teach and care so much about teaching. So can you show us a little bit, how might I do this well in one of these classes?
Yeah, sir. I'll start off and then turn over to you all. I think legal writing is a great place because, as Torrance is already suggesting, the kind of thinking about what makes legal writing persuasive, what makes a citation good or bad, those are important things to be talking about. And this is relevant. I mean, these, especially as a judge, citations help constitute legal authority, and they really matter a lot from that perspective. And so we need to be thinking about that. And then, in addition to that, I think, in my own 1L contracts class this semester, I think talking about these cases is useful when we're thinking about issues of morality, right? These contracts casebooks love talking about, like, why don't we enforce gratuitous promises? Like, what are the morals of morally, what promises the law enforce or doesn't enforce? But what's remarkable is one of the classic cases on this involves two people who owned enslaved people. And there's no question about the morality of that. The law doesn't even question that, doesn't think about that. And I think if we want to think about these big questions about what does the law enforce or not enforce, what promises, what morals does the law enforce or not enforce, this seems like a much clearer and more relevant vehicle than a lot of what we use already. And finally, I think talking about this stuff is just really important for people who are going to be lawyers, because lawyers are real people. Clients are real people. They have gender, class, race characteristics. You have to learn to think and talk about that kind of thing. And so pretending that it doesn't exist is just doing our students a disservice, especially, as you mentioned earlier, Nicole, students who know, in some cases, I tell people in 1Ls, you may know more about how the law actually works than the professor does, because, I don't know, you were a sociology major, or you lived in a neighborhood where you saw this stuff happening, and I think we lose something if we don't take those, we don't build on those experiences and ideas and realize that this, abstraction gets you somewhere, but it also loses a lot, and it loses a lot of stuff, not just the human element, but also the legal element to be successful lawyers. I feel like all of you want to talk about it. Torrance, you want to go?
Yeah, thank you. I was like, this is the question that I was most excited about, because I am writing my upper level writing requirement academic article on this, essentially, about the omission of slavery and broader contextual history as it relates to race relations and race issues in our history.
Are you suggesting you want to come back when it's published so we can talk to you again about this?
Well, if I am so lucky to have it published, then yeah, I would love to do that. But I think at the foundation, it's intellectually dishonest for us to omit a lot of this part of our history. And I think it as a profession and as a area of scholarship in which both society generally looks at us as very intelligent people amongst society because of our education and our job. And as we often, people in our profession think of themselves as well, that I think that we should take a personal issue with intellectual dishonesty where it is so glaring. And I think, like, just for people who are here, think about whether you went to public school or private school, most kids in this country don't learn anything about Reconstruction era. The Reconstruction era amendments exist, but none of the context, what happened, the extension of civil liberties that then are clawed back, that is not an insignificant moment in our history, and it was consequential. And I think that it was one of the most consequential in that we feel that legacy maybe stronger than we would have had we achieved Reconstruction, because I think slavery could have faded to the past a lot more quickly if we didn't obfuscate the facts around Reconstruction and what occurred. And I think that the issue with that is that we have to admit that this is about the people who built our institutions, who write our books, who decide what our curriculum is, has traditionally been the people who are in the power position, or you could say are in the oppressor position. And it is not advantageous for them for us to learn things that would change the narrative about what we feel about our country. But I often say, as someone who's biracial, my mom is white, my dad is black, and this is something I have had to live with my whole life, understanding these two different sides of our America, that we don't have the luxury to act like it didn't exist in an area of scholarship, in a profession where, as I said before, facts are like at the foundation of what we're trying to practice, logic and facts. And so I just think that we have a duty to learn these things. And I think that, for example, it's not going to be great in every single class, but like where it's foundational, where slavery is foundational to how that area of law was built, like contracts and property, that again is just an intellectual dishonesty to admit that. And it's about one of two things. It's about the discomfort or it's about an intentional rewriting of the narrative of our history. And I think that we have to grapple with that. And I think that specifically, miseducation feeds misinformation and false narratives. And I think that we are living in the world that we live in today as a result of some of these forces.
Torrance, a follow-up real quick before I move on to if Misty and Nina want to answer. I know that you're not a law professor, but you do have a history in DEI work, and you have gone through law school, or at least, most of it. The bar is coming for you. Where would you put this conversation about Reconstruction? So we have a mandatory 3-credit Race and the Foundations of American Law class, so we put it there. But for the 190 other schools that don't have this required class, do you put it in con law where it just your opinion, not like you're the constitutional law professor for years and years, but where do you think? Where would you put it?
Well, I think that it is the easy answer that it is constitutional law, mostly because we are talking about constitutional rights. And so that's like the part that I think really frustrates me the most, is that having taken both constitutional law courses here, constitutional law 1 and 2, that we don't go into any Reconstruction cases in those classes. I would advise anyone to look up the Cruikshank case, if that's not something you learned in law school, that like there's these omissions when you find these cases where it's just completely illogical to omit them once you've taken the course. I can't justify why you would leave them out other than to purposefully omit it, and that's something I'm writing about in my article right now. And so I think certainly constitutional law, because we're just talking about cases that we're deciding not to discuss because of what they deal with. And that to me is an issue, because how do you jump from, pre-Reconstruction to the expansion of the Commerce Clause and the retraction of it, and we just decide we're going to discuss nothing about an entire area of property and the extension of, or the ability for Congress to write statutory rights that affect states? Like, that's Cruikshank. I think that that's an issue, and I think that we're not being intellectually honest about it. And I think that we're doing not just our country a disservice, but all of legal educators and legal practitioners.
Thanks. Like, I rarely have these discussions on this webinar because the book series and the webinar series sort of expects that you're looking to do this, that like we never really debate should you. The answer is, well, you may or may not choose to, but if you choose to, here's some help. But I do think for those people who may be interested in or here, or maybe not interested in or here, hearing things directly from a student just hits differently than hearing it from other people. And so while, again, I may have asked you to sort of get out of your expertise for a minute, I really appreciate that just a genuine answer as a student is sometimes way more powerful than, an administrator or your DEI person at your own school. So thank you. And I can go back to the original question for Misty and Nina, if either one of you sort of want to jump in about where in the curriculum might you teach citing slavery? Have you found it? Would it be impactful?
Sure, I can start. Thank you, Misty. I think that you can fit pieces of citing slavery and like the underlying principles in pretty much any class. I mean, I'm thinking about, we have a professional development class, like there's room to talk about it. Contracts, absolutely. Property, absolutely. Constitutional law, absolutely. Criminal law, absolutely. Like I can torts, absolutely. Like what is trespass to chattels? There's one great way to just start opening the conversation, how we still use language that reflects how we treated people as property. And I think the conversation can be relatively natural. And as you mentioned, Nicole, there are resources on how to do that. But beyond like how to create a space in classes, or like beyond what to teach, I think like how to teach is also important. Like Professor Simard mentioned, we read these old cases and contracts about morality, but no one wants to talk about slavery. And we're reading cases for like the 17 and 1800s. And for me, like it's hard to focus. It's hard to be motivated when all I can think about is like the people that we're not talking about. And so being really intentional about how you have those conversations as a professor, and also as a professor making space for students to talk amongst themselves about it, to talk amongst each other about it. And then also thinking about what institutions can do. And also once what you have already done as an institution, like how you can be a leader for other institutions, because other institutions are not the same. Like other institutions don't have the same office you do, or maybe like the same type of land acknowledgement. So like thinking about how you can create a legal field and practice that embraces these particular issues.
And I'm so grateful that you said that. I'm standing here in front of you, or sitting here in front of you, but really Roger Williams and all of my colleagues are sort of all puzzling through this together, and we work together on this. And then there are sponsors of this webinar series who have said, yeah, we're working on this stuff too. And so sometimes it's hard to be a leader on this because you didn't sign up to be a leader. You just tried to do what, your Black Law Students group demanded, or your students are asking about. But it's nice that there's a community of people doing this, and I hope everyone sort of sees it's not as scary as you might think it is, and anyone could do it. It's easier if we do it together. Misty, you're up.
Certainly. And this, where do we teach this kind of thing, brings back memories of the contracts class I mentioned before. There was a particular day in that class where we were talking about a case, and it dealt with the African American or Black person as property. And the instructor seemed to be making just light jokes throughout the class, and it wasn't particularly aimed at the race issue or anything, but there were about, in my cohort, there were about, 6 to 10 African-American students in a cohort of 175, and all of the ones that were in my class were infuriated, many of whom walked out. And one of the people who was infuriated happened to be a very well-respected, I believe at the time he was a 2L student, perhaps a 3L, but he was the assistant to the professor. He was there to help us learn the material. And even he started to raise objection to the way the case was being handled and the dehumanization. And I think it's very important to teach these kind of things before they erupt into a painful fissure like that, because all of those students were hurt. And my school in particular, I'm not going to go into details, but there have been some events that have happened about race and that kind of thing that have hurt them, that were very recent as 2016 at the school I went to, that have still not been fully handled. And I know between that history as well as the way professors talk about or don't talk about at all these cases, all have to do with the reasons that there were only 6 to 10 African-American students in my cohort, and none of them wanted to engage with a lot of things because they felt left out. They felt unacknowledged and minimized, and it was kind of ironic because at the time we had an African-American dean. Dean Marcelin Burke, has since moved on to a different school in New Orleans. But I think it's important to talk about these, sorry, my cat's trying to come say hello. Like Nina said, you can talk about it in contracts, and it was quite funny because despite how our contracts, don't want my cat to step on the screen, I apologize. Despite what my contracts prefer, how he handled the issue, we did have other professors, one of whom was a former Oregon Supreme Court judge, who we spent, I think, at least half a term on the 14th Amendment and the history about it and everything, not just before, not just during, after, everything. And it was a full conversation, and he would allow us to have that conversation, even if it meant sometimes we didn't get to all the material. And it's very important to have that conversation. Unfortunately, that was in my second year. I think it's important to have it at that beginning because it matters. We're talking about people that are still in classrooms, whether we want to acknowledge it or not. The Black students in my school still felt that to that day, and it really matters.
Misty, I don't think what you're saying is unique. I don't think it's, there's one school somewhere that this is happening with one administration. No, that's the default. Exactly. I feel tremendously lucky. I don't there's not even words for how I feel about where I'm at. But it's the work. And I think that our sensitivity towards anyone being hurt in the classroom needs to be increased. But it's hard to be a law professor. We're human. It's hard to be a law dean. It seems even worse. I think they're human. And so I really appreciate your comments, but I just want you to feel, no, I don't know that this could actually make you feel better, Misty, but you're not alone. But it probably makes you feel worse. So I should just move on to the next question. When I first encountered this project, my first thought was the real audience for education about citing slavery should be law clerks and those that supervise them. So much writing of these opinions is done by law clerks. And so have you had opportunities to present to law clerks and their supervisors specifically, and sort of what's the pitch?
Miss, do you want to take this one since you were a law clerk who got the pitch?
The pitch is very effective. I don't remember exactly how it was phrased or framed at the time, but the point that I do remember is that we're using these cases and it impacts people's lives, and the people that we're citing, are people and have names. And I'm very lucky in that the appellate court where I was working at the time was very receptive to these ideas. And the case I was working on at that time may not seem related, but it was a fee case for charging someone who was a low-income African-American person fees for transporting them back to Oregon. And so it was very apt. And everyone after the presentation was very receptive, though it's hard because we are generally a receptive bench.
Yeah, I mean, one of the challenges is reaching clerks in places where sorting through these cases is, a day-to-day thing and not something that happens occasionally. I mean, I think the general pitch we make is this will make you a better, more effective legal writer, right? That this is help you draft better, more persuasive opinions. And incidentally, just a little anecdote. When I presented this paper once, someone came up to me and said, "Oh, I write this practice manual in a southern state, and yeah, I try to avoid citing any of these slave cases." And I'm like, "Have you ever talked to anybody about that or said anything about it?" And she said, "No." And I think we're trying to make those conversations open so that people realize oh, this is something I can be thinking about. It's a category of analysis that I can bring to my judge and say, here's a reason why you don't want to be citing this case.
And if a state court called you, Justin, and said, "Can you come please talk to our clerks about this?" what would you say?
We have and will always say yes.
And that's how you ended up here today. So I unfortunately we are out of time. I really, really appreciate everyone coming today, and sharing of themselves in the different ways, especially today of all days. Our next Integrating Doctrine and Diversity is on November 18th, and it's Unraveling Equity, the Effects of Anti-DEI Legislation on Academic Law Library Workers. And I really hope that people will show up, because law library workers in law schools, to me, are the best, smartest, most amazing freedom fighters ever. And so I really want everyone to hear about what this experience has been like over the last few years for our library policies, but actually for the people who work in those libraries. Again, Misty, Nina, Torrance, Justin, thank you so, so much for coming here today, and have a great rest of the day after Election Day.
Thank you. Bye.